Well, hi everyone. It's Barbara Ann again from the Council on Aging, and with me today is our good friend Michael Lavender, an attorney that works with our Council on Aging every month and has for years and years, even before my time at the Council. I want to thank him for coming. We have a very interesting topic for you today. We're going to talk about the pros and cons of giving your house to your children. Now, I don't say that lightly because a lot of people think that there are many, many reasons to give your house to your children, and we'll talk about some of those. But I urge you to listen to this whole program because it's something that you definitely don't want to miss. So, Michael, can you start us off? I know that there's people that talk all the time at the council of, you know, if I go into a nursing home, what happens? I should probably give my house to put my house in my kid's name, right, before I do that, so I don't have all these tax problems. And he's smiling because he knows that he hears it all the time.
All the time. And what I want to dispel right up front while saying that most people's motivation for doing this is asset protection from a nursing home. And there arises from that a debate about whether this is a good thing to do or whether this is a bad thing to do or whether it's morally right or wrong. And it's neither of the above. And let me just quickly make both arguments. There are those who will argue, well, I've paid taxes all of my year, I've served in the military, I've played by the rules, and now I'm going to get into a nursing home and face a $10,000, $12,000 a month nursing home bill and get wiped out and have nothing to leave to my adult children. That's not fair. And anybody can validate that point of view. And then there's the other point of view where, okay, someone goes into a nursing home and they do the type of planning with a knowledgeable attorney with enough lead time, and they have a waterfront home in Comaquid worth hundreds of thousands of dollars, and they enable that home to pass to their adult children and shift the onus for the payment of their long-term expenses from their resources onto the taxpayer base. And one can argue that that's not fair. And as you can see, neither of those arguments are in and of themselves wrong, but I wanted to dispel that there's any particular moral absolute on this topic. Do you know what I'm talking about?
Yeah, I know that one of the biggest conundrums we have with seniors is we hear all the time they're house rich, cash poor. And what I mean by that is the house is the biggest asset, and yet they're on food stamps or they have not enough money for fuel and need our help with fuel assistance. And don't get me wrong, we're happy to do that and to help you in any way that we can at any time. But at the same time, sometimes these same people are living in this ginormous 6-bedroom home and they can't afford it, frankly. So then we get the questions of, well, in order for me to stay here, what I'd like to do is, and they go through all different kinds of things in their, quote, estate planning, but in assets, this is really the largest asset that they have. And they come to us and say, I don't know what I should do. Should I sell it and go into a condo? But then what do I have to give to my kids? And the phrase, what do I have to give to my kids, drives me crazy because I don't want people to bankrupt themselves or to have themselves become so impoverished because they, quote, want to leave something to their children. I can tell you that 99% of the time, when my staff and I talk to those children, they don't want their parents to be in that position. They want their parents to live well and healthfully and financially healthfully as well. So there are many reasons that people will come to us to want to do this, but I asked Michael here because he is more obviously of an expert on when you should do it or how you can do it.
Or whether.
Is it legal, whether it should be done at all, whether you should stay and have help come in your home, et cetera, et cetera.
So I just wanted to pick up on Barbara Ann's point. It's as if we speak to the same people. And when I was a younger Michael, I used to very much beat the drum of you need to transfer your house now to your children. You need to get ahead of the disqualification rule. You need to put asset protection or preservation of an inheritance as not only a financial planning strategy, but the financial planning strategy. And I would, in so doing, often villainize the nursing homes as if they're not entitled to pay their expenses either. And what I saw over the years as I became older and started practicing 10 years, then 15, then 20, now 25, is the people whom I were counseling back in the 90s now are in their 80s and more, some of whom have already made this transfer, and for many reasons regret that they have done that. And I'll give you a couple, just a few examples off the top. The one that I find most poignant is the one where the spouse has passed away and the surviving spouse wants to move into assisted living. And no one wants to be a burden to their children, yet now the house is in the children's name, and now it's really up to the children whether or not the house can be used to defray the expenses of the surviving parent living autonomously in assisted living. And what the client can usually do at that stage, because they're older with a shorter life expectancy, is to convert that home to money, and that with their even meager Social Security or survivor pension can be enough to bridge the gap of their remaining life in an assisted living. Now, I'm not talking nursing home here. I'm talking an intermediate living type arrangement, which has become more and more prevalent over the past 2 decades. And that's I'm not going to name places or promote any particular place, but it's usually you have your own room, it's restaurant-style dining, it's supportive and assisted living, it's not a nursing home. And my point here is if the profile that Barbara Ann discusses, which is mostly all of their equity is tied up in their house, is beyond their reach, now they don't have the ability to make that financially autonomous decision of how they live their latter years. They now become beholden to their adult children as to whether that happens or not. And I'm putting aside tax consequences and other things that we won't even get to today. So I just want to leave some space for Barbara to comment on that.
Michael, what is the look-back period now? Is it still the 5-year? They talked about going to 10-year at one point.
And let me describe what the look-back period is, because it's often misunderstood. People will say to me, well, my house is safe in 5 years, or something like that. And the reality is what is happening for people who give their home away, or make any gift, by the way, and that means adding their house, their adult child to the name, to the deed, thank you, as opposed to an outright transfer. All of those trigger a 5-year transfer penalty, and what that means is that if they apply to the Massachusetts government to help defray the cost of long-term care, that transfer will have rendered them ineligible to gain access to those benefits. So they apply, and someone from the department looks over their past 5-year financial history, and they see a transfer, and that transfer doesn't mean that they're going to go grab the house, but it does mean that unless some type of payment structure is figured out within the family or the home is returned, that they will not be able to access the funds necessary to pay for that skilled level of care, which, by the way, on average is $10,000 to $12,000 a month. That's the look-back period.
And what people don't realize is it's monies as well as homes and other things. Is that correct? So if you transfer
that's correct, yes.
$50,000 to your grandchild for their college education, that $50,000 of your asset money, that is your income, your asset, is also looked at. So it isn't like, oh, well, I'll just give it all to the grandkids. I won't do the house, but I'll do the money to the grandkids. It's looked at similarly.
And that makes me sometimes sad, because the other side of that argument is you can't live your life because of Medicaid's rules. Sometimes these transfers have legitimate purposes, such as bailing an adult child out of financial difficulty or paying for a grandchildren's college education. You know, these are not efforts to defeat the law in any way. There are legitimate ways that the parent wants to help their family members. And so when people ask my opinion about whether they should or shouldn't do that, I tend to be a little bit evasive because I don't have a crystal ball. And I like to use the phrase of you can't live your life for Medicaid, but please do know that if you do that, and Mr. and Mrs. Smith, where I notice that you already have failing health, and 5 years for me is probably no big deal, but 5 years of independent living for you is questionable, you need to know that this transaction will have that consequence, and maybe even have a family discussion around it, maybe even escrow the monies until that period has elapsed. I mean, there are options you can do that don't put you in a situation where you need the care and the only funding source available has been transferred.
We did have it's not funny, but it was kind of a funny situation with a person in town that was talking about she thought the best way to get around this problem with the whole house thing was to do a mortgage, not a reverse mortgage, but there was no mortgage on the home. So at a very late age, she decided to do a 25-year mortgage. And the bank person said, I don't even know if we should do that at the age that you're at because you're probably not going to live long enough to be able to pay the mortgage off. So she's smiling. Well, that young lady is now 108 and is pretty darn close to the end of the mortgage. So the point in my story is when you go to do some of these things, you may think, well, by the time I get to be 91, 95, I probably won't be here anymore, so I don't have to worry about that. Really plan that you will be to 100 and go from there, because she didn't think she was going to be 108 either, and she's very much looking forward to turning 109 next November.
Wow, wow. What's the oldest person that you have seen in the senior center?
She is right now, she's the oldest person on record that we know of in Harwich at 108.
Wow. I just wanted to hit a couple of the big ticket items on this issue, ones that are, usually I lead with these ones actually. When you, and getting back to the house, when you add an adult child's name to the deed of your home, you in most instances expose that home to any of the negative life circumstances of that adult child. There is a lot of divorce going on in my generation. I believe the rate is about 50%, and I have seen many worst case scenarios where the home has been transferred to the adult child for the same purpose of asset protection from a nursing home, and then years later the spouse of the transferee sues the adult child for a divorce, and now the home, which in the mind of the senior is still their home, but now it's marital property subject to divisions under the domestic relations laws, and that can get very, very complicated. There are ways to mitigate that, but my point being is that I'm just speaking about divorce as the hypothetical. It can be anything. It can be an automobile accident where there's not enough automobile insurance to cover the liability, and so therefore if there's any excess liability over the insurance, then the adult child's assets, which now includes their parent's home, is now liable for any of those consequences. And this is something that can be in the area of unpaid taxes, unpaid credit card bills, bankruptcies. In short, all of the life misfortunes of the adult child now can become the problem of the senior because their name is on the deed, which is their primary residence.
So if you had a couple who got divorced and it's, say, Johnny and Susie sues Johnny because now I want part of your mother's home and estate, if Susie has a good lawyer, there is a chance that the senior could have that home become part of that Susie's, be sold because they have the lawsuit, and it ends that Susie will get some money out of that house, short of Johnny buying her half out.
It's a sad prospect, and it's also a complex area that goes into both estate planning and divorce law. The way I've mostly seen things like that play out is the divorce lawyer representing the other spouse, if you will, says something along the lines of, we will keep our hands off your parents' house as long as you hand over fill in the blank. It just becomes a leverage tool, but it's definitely there. Just as a parenthetical, there are ways of structuring these transfers that can defer those kinds of problems, but defer only, not defeat. There are ways of structuring these so that the senior can never be evicted from the home, but the ultimate consequence of that home having a lien on it, subject to the adult child's creditors, would be an ongoing thing.
We did have a really sad one where the adult child had came down with cancer and had no insurance at the time before Obamacare, and so the medical bills were in the hundreds of thousands of dollars, and guess what? The house was in multiple people's names, the daughter, her sister, and mom, and then dad died. And it ended up upon, as you said, for a while, bantering back and forth because the hospitals and the people who needed to be paid their medical bills, and deservedly so, were not going to just write off these hundreds of thousands of dollars. Right. So I guess what we're trying to say is it's not that it's necessarily a bad idea, it just needs to be very carefully looked at, first as to how much of an asset it is, dollar-wise and value-wise. Second, emotion-wise, because if it's the house that you grew up in, my husband and I joke that the house that I left in Westport, Connecticut, it's the only house I ever knew growing up. When it was sold, I was sobbing driving away from that house, thinking that it was, you know, such an emotional attachment to all of childhood memories. And sometimes adult children don't realize that until you actually have the other person walk in and say, yes, I think I'd like to buy this. And then it's almost too late sometimes. So it really needs some careful planning with the right kind of lawyer, which brings me to the question, Michael, who is the right kind of person to do this if indeed it was something that was necessary and the senior wanted it, but they also don't want to get rooked or have something terrible happen?
Well,
is it just an elder law attorney, or is there a different specific?
Let me just respond to that. You raised so many questions, all of them in the question itself. It's always helpful to go to an attorney who has a lot of dealings with the elderly. And the reason for that is I see people who have come to me after the fact, and I express all of these concerns, and they say to me, well, geez, my lawyer never told me any of these things. The only thing that he focused on was the fact that you better do this or the nursing home's going to get your house. And then all of this other stuff was you know, not even
in the conversation.
In the conversation. And so my point is not to not do this, but if one is to do this, to be able to make an informed decision and be able to balance the risks accordingly. Are the adult children people who have solid marriages, who are creditworthy and not going through divorces or alcohol problems or any kind of life difficulties that give rise to predictable problems or not? You need to analyze, you know, the situation in its entirety. And so getting back to your question, I think that it's best to have this discussion with an attorney that has some involvement with public benefits laws, the 5-year period, or just deals with seniors as a significant part of their practice.
There's one of the issues that we come across all the time that Michael is also referencing is mass health. We call it in our state, and Medicaid laws are very, very specific, and they do talk about the look-back period. They talk about what you can have in assets, what you can't have. And so if you get, if you're an adult child listening to this and you just say, you know, my mother's had a lawyer for 45 years and that's who we're going to use, well, the lawyer may be very, very expert at just law, but maybe not elder law, maybe know nothing about Medicaid or very little, or maybe he took a, you know, refresher course 5 years ago, but the laws have all changed since then. So you really want to make sure when you're lawyer shopping, for lack of a better way to put it, that you really have an expert in that area. Just as you wouldn't want to go to get a divorce with someone who doesn't have any divorce, you know, law experience background, or you wouldn't want to go to someone who needs a mediator simply by just going to an elder law attorney. You need the right kind of expert to deal with your situation. And if you're not sure what that is, you certainly can ask anyone in our department. We have a lot of elder law attorneys that we work with, and some of them, like Michael, have specific things that they are expert in, and we certainly want to get you to the right place. We don't do a recommending of one person, but we can tell you, these 3 or 4 people specialize in this, or they don't, and you definitely want to. It's just like looking for your doctor. You want someone who has some idea of working with seniors. You don't want a pediatrician, for example, working with an elder. So it's the same kind of thing with looking for a lawyer. You want to get the right one, the right kind.
One more point that I would like to make on this number of considerations, which is more subtle, but very, very relevant to seniors and the profile that they present around this issue, and it has to do with tax, believe it or not. Most seniors have, not all, but most seniors have a home which they purchased years and years ago for $50,000, as an example. And now the house has appreciated to, let's just say for the sake of our example, $300,000. Now, putting aside any improvements or anything of that nature, you have a difference in value there of $50,000 and $300 or $250 in what's considered capital gain, capital gains tax. Now, homeowners under federal law who have lived as their home 2 out of the 5 past years can exclude up to $250,000 under statute of capital gains, and if they're a couple, up to $500,000 in capital gains. Now again, this applies very frequently with seniors because it's most commonly the seniors who bought this home years and years ago and has appreciated all this much by years of ownership. And now the issue comes up as let's transfer the realty to the adult child. Now, if that has been done and the parties decide to change horses and sell the home before the death of the senior, obviously the adult child cannot take that capital gains exclusion of $250,000 because it's not their principal residence. The senior cannot, in most instances, take that because they are no longer the owner of the home. Yes, they reside there, but no longer own it. And so what happens is the house is sold is the parties have just made a very unwitting gift to the Internal Revenue Service because in most instances we're dealing with what's called low basis real estate. And so I would feel remiss if I didn't make that specific point also. And that gets us back to the areas of how many people are tuned into the subtle nature of these real estate transfers as it relates to senior citizens.
So Michael, if you, in that same scenario, if you didn't transfer it but you put them also on the deed, is it still the same? If mom is on the deed and daughter is on the deed?
Not quite. What I'm talking about here is an outright transfer with no strings attached. If, and this gets into a more complicated area of the tax basis rules, but let's say an adult child is added to the deed, you still have all of the other issues of exposure to creditors, you still have the 5-year transfer penalty, but in terms of the capital gains tax exclusion, you would still have, the senior would be able to retain that in relation to their proportionate share of ownership of the property.
Oh, okay.
So that would be retained. Okay. Or, without getting into it in any great detail, if the house ultimately passes to the adult child by death, then the adult child receives the home with what's called a stepped-up tax basis, valued and measured at the date of death of the senior. So in an odd way, one of the ways around capital gains tax is dying, owning the property. Odd, but true, and has been true for a long, long time.
Wow. Well, I can't thank you enough for being here, because it's a question that we get in our outreach department a lot, and we get it myself as the director just in casual conversation. Sometimes it's a lunchroom conversation, and there's times when you want to just say, wait a minute, you know, kind of, you don't know exactly all that you're talking about, and it's not, you know, the lunchroom or a sidebar conversation is not the right place to be able to be talking about capital gains and the ways that things can negatively impact you by trying to what you're thinking you're doing is the right thing. So I would urge you, if it's something that you're considering, that you either talk to Michael maybe when he's here, or you talk to one of us as an idea to try and find the right attorney. But I'm more concerned if it's someone who has already done this. I think it's something you really want to look at what those documents look like that you had drawn up, just so you don't get yourself into that position, or if you are, at least you're armed with the knowledge of what could happen later on. We do have another message that kind of goes with this is we are headed into crummy weather coming up, potentially. Winter doesn't always have crummy weather, but it often does give us some snow and some ice and sometimes some storms. And I just want to give people a reminder, when we were talking about assisted livings, that we have some fabulous assisted livings and nursing facilities that are our community partners when we have storms, and they will take on an emergency basis people that I call them with so that they don't go to a shelter. So for example, the 108-year-old that I was talking about loved the facility so much that she stayed in, that now, if you can believe it, at 108, decided she wanted to live in an assisted living the rest of her life, whatever the rest of that may be. So they're wonderful community partners. They're really helpful in housing people for a day or two, as long as they don't need anything except a bed and to be fed. And I want to thank them for that. In addition, they are really great options for winter. If you want to do what we call a little vacation stay, you can go for the winter months to one of our local facilities and just stay the winter, and then when springtime, late March comes, go back to your home. So a few things to think about when we're talking about what you want to do with your house or not do with your house. If you are really feeling like, I'm in this big old house and I'm all by myself and I'm a little bit nervous again with the snow this year, it might be an option for you if you've got a little bit of money tucked away and you want to be safe and not be home alone again. So Michael, thank you very much. Michael is here every month and has been for a very long time with us, volunteering his time at our Council on Aging, because he realizes how important elder law is for seniors and that many people cannot afford it. So I thank you so much for being here and for being at our council all the time. And I wish all of you out there wonderful holidays, starting with Thanksgiving. Thanks for tuning in.
Thank you.